special counsel's investigation of former President Donald Trump. Our senior legal affairs correspondent Paula Reed is joining us right now. Paula, tell us about this New York Times report and why potentially it is so significant.
An incredibly significant development in the special counsel investigation. The New York Times reporting that Trump's former White House chief of staff, Mark Meadows, has testified before the grand jury that special counsel Jack Smith has been using in both of his investigations, both into January 6 and also into the possible mishandling of classified documents down at Mar-a-Lago. Now, according to the Times reporting, it's unclear if he has testified in just one of those investigations or in both. But he is arguably the most significant witness that the special counsel could speak to, certainly in the January 6th investigation, but he could potentially also have valuable information in the classified document probe as well. Now, in recent months, folks around former President Trump have expressed some concern, some puzzlement about exactly what was going on with Mark Meadows, because they told us that they didn't have any communication with his legal team.
Hey everyone, John here. The real answer might bother you. The most dangerous witness in Trump's trial isn't an expert or a cooperating co-defendant. It's someone who was in the room. Mark Meadows can testify. I was there. I told him. He knew. And he did it anyway. That kind of first-hand testimony is devastating. For 13 weeks between November 2020 and January 2021, Meadows occupied the most powerful staff position in the Western world. He was Donald Trump's chief of staff during the final year of his first term, the year when American democracy faced its most severe test since the Civil War. He ran the West Wing during the period prosecutors have described as a coordinated scheme to obstruct the certification of a presidential election. He sat in on conversations about fake electors being manufactured in states Trump lost. He was present for the discussions about pressuring Vice President Mike Pence to reject legitimate electoral votes. He listened to the phone calls where Trump demanded state officials find votes that did not exist.
They were unclear what exactly was going on with him. They've even said on our air that there was no communication between Trump's legal team and Meadows' legal team, which raised a lot of questions about whether he was indeed cooperating with investigators. Now, in terms of what he could offer on January 6th, the House investigation into January 6th basically concluded that all roads led to the former White House chief of staff. All the communication to the former president that day, including from his own family, went through Mark Meadows. He would have an incredible number of questions to answer before investigators. Now, also, though, on the Mar-a-Lago probe, we learned from our exclusive reporting in recent weeks that investigators have an audio recording, a really key piece of evidence where Trump refers to being in possession of a classified document. And that recording was made by Meadows' autobiographers who were recording in the room. Now, in a statement Meadows' lawyers provided to the Times, they said, quote, "Without commenting on whether or not Mr. Meadows has testified before the grand jury or in any proceeding, Mr. Meadows has maintained a commitment to tell the truth or his illegal obligation to do so." Wolf.
He received intelligence about the planned January 6th rally and the potential for violence that came with it. He was the man whose job required him to know what the president knew, to manage the information flowing to the Resolute desk, and to be present for every conversation that shaped the decisions Trump made. Now, according to multiple confirmed reports from ABC News and other major outlets, Meadows has already walked into a federal grand jury room, raised his right hand, and told prosecutors under oath that he repeatedly warned Trump after the 2020 election that the fraud claims the president was publicly promoting had no evidentiary support. Think about the weight of that statement. The chief of staff, the man who ran the entire White House operation, telling federal prosecutors that he personally informed his boss that the election fraud narrative was baseless, and that his boss continued pushing that narrative anyway.
And I want to just point out that one well-placed source has now confirmed to CNN this report about Mark Meadows testifying before this grand jury. What does this tell us, Paula, about where the investigation is right now?
Well, as we've been reporting over the past several weeks, it appears that this investigation is in its final phase, based on the types of witnesses, the requests that they have, the fact that they're bringing people back. But the thing that we've said repeatedly on air, including on your show, Wolf, is we just don't know about Mark Meadows, right? That is such a significant witness. Once they talk to him, then we can say for certain that this is definitely in the final phase and likely wrapping up. But of course, we know that the investigation continues. Investigators are expected to speak to at least one more witness in Florida later this week. But the fact that they have talked to him, that this has finally been confirmed, this is something we've been waiting for to really understand whether they are indeed wrapping up this investigation. It appears, again, this is one of the most significant witnesses they would speak to. This is someone that it appears that they've likely spoken to in this final stage that we're entering now, and they contemplate whether they will indeed bring any charges.
Yeah, let's not forget this is a criminal.
If that testimony holds up, it goes directly to the single most important question in the entire federal election interference case. Not whether fraud occurred, not whether Trump sincerely believed it occurred, whether Trump knew it did not occur and promoted the claims anyway. This is the testimony that prosecutors dream about. This is the testimony that makes defense attorneys lose sleep. And Mark Meadows has it. The development has sent shockwaves through Trump's inner circle. CBS News has confirmed that Meadows is cooperating extensively with special counsel Jack Smith's investigation into efforts to overturn the 2020 election. Sources close to the former president describe a palpable sense of unease, an anxiety that has settled over Trump world like a fog that will not lift.
Investigation of Donald Trump that we're watching right now. Paula, stay with us. I want to dig deeper with our legal and political experts who are standing by. Elliot Williams, let me start with you. How critical is this Mark Meadows testimony before this grand jury?
It's very critical, Wolf, and for a big reason. Let's look at the role that Mark Meadows would have played in the Trump White House. As chief of staff, he would have had access or insight into political questions in the White House, but also substantive ones. And so look at the two different inquiries that are happening here. To the extent that he could provide insight as to January 6th, he could talk about what the president said, what the president knew. Did the president ever convey that he knew he lost the election? What was in the president's mind? What was his state of mind around the statements he made on January 6th? And other activity there. So there's plenty to be gleaned from him there. With respect to documents, it's an entirely separate investigation, but he could also provide insight into what did the president know was being packed up in boxes on the final days of the administration and being sent down to Mar-a-Lago. What did the president say about his right to declassify documents or that he knew was in his possession? There's plenty that can be asked of Mark Meadows again.
Meadows has been present for every critical moment from election night through the certification process. He was on the phone with Georgia Secretary of State Brad Raffensperger when Trump demanded that the official find enough votes to reverse the outcome. He attended meetings where the fake elector scheme was discussed and developed. He received text messages from Republican members of Congress proposing various legal theories for stopping the certification, theories that even they acknowledged were legally questionable at best. And here is where the story becomes even more compelling. Meadows is not just a witness, he is also a defendant. He faces criminal charges in Georgia alongside Trump and 17 other co-defendants in the sprawling RICO case brought by Fulton County District Attorney Fani Willis.
As both a substantive and political aide, he was clearly a critical witness.
He certainly was. And Kerry Cordero, he was key. He was well known in the White House, obviously the White House chief of staff, but he was key to various aspects of both of these investigations, presumably. That's why they want to question him, the January 6th insurrection, as well as the classified documents that were lying around Mar-a-Lago.
That's right. And as Elliot and Paul explained, because he had so much access, because he was in the position that he just had firsthand knowledge. I think the fact that he has testified now before the grand jury, and one of the big questions I have, Wolf, is did he actually testify from a substantive perspective? In other words, answer questions substantively, meaningfully, for what amount of time, how many hours was he in there? Or was there a circumstance where he would have been in a position to invoke his own Fifth Amendment right? I mean, I think one of the big questions is whether or not Mark Meadows faces any criminal liability in these broader investigations himself.
He is also charged in Arizona's fake electors case. He has pleaded not guilty in both proceedings. But his legal situation has created an impossible set of incentives that no other person in Trump's orbit has ever confronted. Let us examine what makes Meadows uniquely dangerous as a witness. The chief of staff is not a peripheral figure in any White House. This is not someone who attended a single meeting or overheard a conversation from the hallway. This is the person who controlled access to the president, who sat in on the most sensitive discussions, who managed the flow of information to the commander-in-chief, who coordinated with outside allies and legal advisors, and who personally witnessed the decision-making process unfold in real time. Meadows served from March 2020 through the end of Trump's term, but it was those 13 post-election weeks that have become the focus of intense legal scrutiny. During that period, Meadows was physically present in the West Wing as the events unfolded. He was on the speakerphone during the Raffensperger call. He was in the meetings about the fake elector strategy. He was receiving urgent messages from members of Congress, outside lawyers, and political operatives, all suggesting ways to stop the certification and keep Trump in power. The text messages he produced to the House January 6th committee show him at the epicenter of a vast web of communications about these schemes. Witnesses who testified before the committee confirmed that Meadows was warned that the planned protest could turn violent. He was told that Pence did not have the legal authority to block the certification. And despite receiving those warnings, despite possessing that knowledge, the White House continued pushing its pressure campaign against the election results. All of this information resides in Meadows' mind. All of this is what he has reportedly told federal prosecutors under oath, with limited use immunity, in front of a grand jury. And we have not even addressed what a New York Times profile of Meadows described, calling him the least trusted man in Trump world, with MAGA insiders privately convinced that he has cooperated far more extensively with prosecutors than he has publicly admitted. The suspicion that Meadows has been quietly handing prosecutors the roadmap to a conviction has become something of an open secret among Trump's closest allies. Think about the position this man occupies. He has been pardoned by Trump for federal crimes, yet he remains charged in Georgia and Arizona. He is simultaneously a witness in a federal investigation that has been paused by Trump's return to the presidency and a defendant in state cases that continue to have teeth. He is trusted by no one and needed by everyone. Let us break down the specific testimony Meadows reportedly provided and understand why prosecutors consider it so extraordinarily valuable. The central legal question in the federal election interference case was never about whether Trump engaged in specific acts. Those acts were largely matters of public record. The Raffensperger call happened, the January 6th rally happened, the tweets pressuring Pence happened, the fake elector plan moved forward. The question was always about intent, about what was going on inside Trump's mind when he took these actions. The charge of conspiracy to defraud the United States requires prosecutors to prove that Trump intended to obstruct and impede the legitimate functions of government, specifically the certification of the Electoral College results. This requires showing that he knew he was pushing a fraudulent scheme, not pursuing a legitimate good faith legal challenge. The difference between a legal strategy and a criminal conspiracy often comes down to what the defendant knew, and that knowledge requirement is precisely where Meadows' testimony becomes devastating. If Meadows informed prosecutors, and the reporting indicates he did, that he told Trump on multiple occasions after the election that the fraud claims had no evidentiary support, then every subsequent public statement Trump made promoting those claims carries a completely different legal meaning. It is no longer possible to argue that Trump was acting on genuine belief when he told crowds the election was stolen. The person who ran his White House told him the claims were baseless, and he kept making them anyway. That is the very definition of knowing falsity. And knowing falsity in the context of a scheme to use those false claims to obstruct the certification of an election provides the intent element that prosecutors need to establish criminal liability. The documentary evidence already in the public record reinforces the power of Meadows' testimony. Before he ever appeared before the grand jury, a significant body of evidence about his central role had been assembled by the January 6th committee. Meadows initially cooperated with that committee, producing texts and documents before eventually refusing to testify in person. The texts he produced were among the most revealing documents in the entire investigation. They showed him receiving messages from Republican members of Congress in the days leading up to January 6th. These lawmakers were proposing theories for how the certification could be stopped, theories about state legislators decertifying their election results, theories about how Pence could be pressured to reject specific electoral votes, theories about running out the clock to create chaos and prevent certification from being completed. They showed him receiving communications from outside lawyers and operatives, including Sidney Powell and John Eastman, about the legal theories they were advancing, theories that multiple courts had already rejected. They showed him receiving a text that acknowledged violence could occur at the planned rallies, a text presented to the committee as evidence that the White House had been warned about the potential for violence. And they showed him communicating with Trump's allies about the fake elector strategy, the plan to have Republican electors in states Biden had won submit fraudulent certificates declaring Trump the winner, which could then be used to give Pence a basis for rejecting or delaying the certification. All of this documentation predated Meadows' grand jury testimony. It established his central role in the events without relying on his credibility as a witness. Now let us discuss the limited use immunity deal and what it means legally. This is a critical point that much of the media coverage has either simplified or misunderstood entirely. Limited use immunity, also called use immunity, means the government cannot use Meadows' own testimony against him in a criminal prosecution of Meadows himself. It does not protect him from prosecution entirely. It does not immunize his conduct. It simply prevents the government from using his own words as evidence against him specifically. He can still be prosecuted for anything the government can prove through other evidence that does not derive from his testimony. And here is the key point. The immunity deal does not limit how his testimony can be used against other people, specifically against Trump. The immunity arrangement is designed specifically to allow the government to obtain information from a witness who might otherwise invoke their Fifth Amendment right against self-incrimination. By giving Meadows limited use immunity, Jack Smith's office could compel him to testify without Meadows being able to assert the Fifth Amendment, and the testimony he gave under that compelled immunity, describing Trump being told the fraud claims were false and continuing to push them anyway, can be used against Trump in any prosecution of Trump. The deal protects Meadows from having his own words used against him. It does not protect Trump from anything. This is the specific legal mechanism that makes the immunity deal so significant from a prosecutorial standpoint. It is why the New York Times profile of Meadows, calling him the least trusted man in Trump world, resonates so clearly with people who understand how cooperation deals work. Trump's base suspects Meadows of having given prosecutors far more than he needed to. The structure of the immunity deal makes that suspicion legally coherent. Meadows has spent the post-election period in an impossible position. He is caught between two competing legal and political risks that pull in exactly opposite directions with equal force. If he cooperates fully with prosecutors and provides testimony that results in a prosecution or conviction of Trump, he becomes permanently persona non grata in the political world where he built his career. The MAGA movement he served as chief of staff, the base that once cheered his loyalty, would view his cooperation as the ultimate betrayal of a political family. He would become another Michael Cohen, the former fixer who cooperated and was immediately discarded and reviled by the movement he once served. But if he withholds information, minimizes his testimony, or refuses to cooperate, he risks being prosecuted himself for conduct that the Georgia and Arizona state cases still cover, and that federal prosecutors might still be able to establish through other evidence that does not depend on his cooperation. He could end up in prison, not for cooperating too much, but for cooperating too little, while the state cases proceed without the benefit of the federal immunity deal he was given in exchange for his testimony. He is simultaneously a person Trump has issued a federal pardon for, suggesting some ongoing effort to maintain the personal loyalty relationship and create a financial and legal disincentive for further cooperation, and a person Trump's inner circle privately describes as someone who has been talking far more than he lets on publicly. The federal courts have already ruled on Trump's attempt to block Meadows' grand jury testimony. Trump's lawyers went to court and argued that conversations between the president and his chief of staff were protected by executive privilege and could not be compelled as grand jury testimony. The judge rejected that argument. Meadows would testify, and whatever Meadows told the grand jury, he told it over Trump's active legal objection. The president of the United States tried to use the executive privilege of the presidency to block his own former chief of staff from testifying to a grand jury about what they discussed. The court said no. The reported testimony Meadows provided goes to the very heart of what prosecutors needed to establish criminal liability. Consider how this case would have unfolded if it had proceeded to trial. Prosecutors could show that courts had rejected the fraud claims. They could show that the Cybersecurity and Infrastructure Security Agency said the election was the most secure in American history. They could show that Attorney General Bill Barr told Trump there was no evidence of widespread fraud and received a response that Barr had become a real disappointment. All of that would be circumstantial evidence that Trump was informed his claims were wrong. But what Meadows provides is direct evidence, testimony from the person who ran the president's White House, who was in the room for the most sensitive conversations, stating that he told Trump personally and repeatedly that the fraud claims were not supported by evidence. The legal distinction between circumstantial and direct evidence matters enormously. Circumstantial evidence supports an inference. Direct evidence establishes a fact. Meadows' testimony, if accurate and accepted by a jury, directly establishes that Trump knew the fraud claims were false when he continued to make them. That is not an inference. That is a statement from the Chief of Staff under oath. The documentary evidence from the texts Meadows produced to the January 6th committee creates a corroborating framework that makes his testimony significantly more credible than it would be without it. A cooperating witness with an immunity deal is always vulnerable to the attack that he is saying what prosecutors want to hear in exchange for protection. That attack is harder to land when the testimony is corroborated by documentary evidence that predates the cooperating agreement. Meadows' texts, produced before he sought immunity, before he was a cooperating witness in a different proceeding, show him at the center of communications about fake electors, pressure on Pence, and plans to disrupt the certification. Those texts do not require a jury to believe Meadows' credibility as a witness. They are documents. They carry their own evidentiary weight. And when his grand jury testimony describes the same events and conduct that the texts independently document, the corroboration between the two sources of evidence creates exactly the kind of converging evidentiary structure that makes prosecutorial cases hard to defend against. The state cases in Georgia and Arizona represent the legal pathway where Meadows' evidence still has active consequences, even with the federal cases closed. The federal election interference case was dismissed when Trump won the 2024 election, and DOJ policy prohibited prosecution of a sitting president. But Georgia's state RICO case and Arizona's fake electors case are state proceedings that the DOJ policy does not reach. Trump's federal pardon covers the federal charges. It does not cover the state charges. Meadows has pleaded not guilty in both. The Georgia case remains technically active, delayed by litigation over Fani Willis's authority to prosecute following revelations about her personal relationship with the special prosecutor she hired. But the case has not been dismissed, and multiple co-defendants have already pleaded guilty and entered cooperation agreements. What Meadows knows, what he has told federal prosecutors, and what his texts already document is directly relevant to the state racketeering charges that remain pending against both him and Trump. State cases are where the presidential immunity doctrine provides less automatic protection, where federal pardons provide no protection, and where the evidentiary record that Meadows can provide still has live legal consequences. The least trusted man in Trump world dynamic reveals the specific way that close proximity to power becomes a legal liability when things go wrong. Meadows spent 4 years building a career inside the MAGA political movement. He was a Freedom Caucus congressman. He was one of Trump's most loyal House members. He was selected to be chief of staff because of that loyalty. And now, because of the things he witnessed and the conversations he was part of during the most consequential weeks of the Trump presidency, he is simultaneously a person Trump has pardoned, a person Trump's allies suspect of cooperation, a defendant in 2 state criminal cases, and a witness in a federal investigation whose full testimony has never been made public. The pardon could be read as Trump trying to maintain the loyalty relationship and create a disincentive for further cooperation. The private suspicion among MAGA insiders that Meadows has been talking more than he admits could be read as intuition about what a person in Meadows' position rationally does when facing potential prison time. And the legal structure of the limited use immunity deal, designed to compel testimony over a witness's Fifth Amendment concerns, could be read as prosecutors having already gotten what they needed from from him, regardless of what he says publicly about the extent of his cooperation. All of these readings lead to the same conclusion. Meadows knows more than he has said publicly. He has told prosecutors some or all of it. And the gap between what he knows and what has been made public is the dimension of this story that is most consequential and least resolved. The federal election interference case is closed. Jack Smith's office has been shut down. The federal grand jury investigation ended with Trump winning the 2024 election, but the evidentiary record those proceedings produced does not disappear. The testimony, the documents, the texts that Meadows produced, the immunity agreements, the grand jury record all exist and are preserved. Future prosecutors can pursue leads developed in federal investigations, even if those prosecutors are state-level prosecutors working in state courts under state law. If the Georgia RICO case ever reaches trial, if the months and years of litigation are eventually resolved and the case proceeds to a jury, the evidence Meadows has provided as part of the investigative backdrop becomes available. State prosecutors can subpoena him as a witness. They can introduce the texts that are already in the public record. They can develop their own independent evidentiary case, drawing on the same events and conversations that the federal investigation documented. Meadows himself remains a witness whose full sworn testimony has never been tested in open court. He has never been cross-examined in front of a jury. The immunity deal has never been presented to 12 jurors who had the chance to evaluate his credibility and the consistency of his account against the documentary record. The reporting says he told prosecutors that Trump was warned the fraud claims were false and continued making them anyway. If that account is accurate, and if it is ever presented to a jury in a proceeding with the full evidentiary apparatus of a criminal trial, cross-examination, corroborating documents, competing testimony, arguments from both sides, it is the kind of insider testimony that changes the shape and feel of a prosecution in ways that no amount of documentary evidence alone can replicate. Mark Meadows' testimony that Trump was warned the election wasn't stolen and chose to say it was anyway could be the key that connects all the evidence to Trump's state of mind. It's the kind of first-hand account that makes a jury understand not just what happened, but what Trump knew while it was happening.